Business Law Business Law Partnership Part 3. Prohibition on a limited partner. A limited partner cannot contribute service to the partnership. If he will contribute services or takes active part in the management of the business, he shall become liable as a general partner. His surname should not appear in a firm name. If he allows his surname to be used in a firm name, he shall be liable as a general partner to persons who extend credit to the partnership without actual knowledge that he is not a general partner. He shall not be liable, however, if his surname is also the surname of a general partner, and his surname has been used by the partnership prior his admission as a limited partner. He cannot be a proper party to proceedings by or against a partnership. The only exception is when the object of the proceedings is to enforce his liability against a partnership or when a partnership has a claim against a limited partner. Rights of a limited partner. To require the partnership books be kept at the principal place of business and to inspect and copy the same reasonable hours on business days. To demand true and full information of all things affecting the partnership. To demand a formal account of partnership affairs whenever circumstances render it just and reasonable. To demand dissolution and winding up by decree of court. To receive share of the profits and other compensation by way of income. To demand a return of his contribution. To assign his interest in the partnership. The assignee cannot exercise the right of a limited partner unless he becomes substitute limited partner. A substituted limited partner is a person admitted to all the rights of a limited partner who has died or has assigned his interest in a partnership. To become a substituted limited partner, there must be consent of all the partners or the assigner has the power under the certificate to assign one, and a certificate must be appropriately amended. The substitution of the assignee as a substituted limited partner does not release the limited partner for liability of the partnership. To give consent before some actions of the general partner may be implemented. The consent of all limited partners is necessary if the general partners will do any act in contravention of the certificate, do any act which would make it impossible to carry on ordinary business of the partnership, confess a judgment against the partnership, possess partnership property or assign their rights in specific partnership property or for other partnership purpose, admit a person as a limited partner unless the right is given in the certificate, and to continue the business without partnership property on the death, retirement, insanity, civil interdiction, or insolvency of a general partner unless the right is given in the certificate. To extend loan or enter in contract with the partnership. Right. In relation to the partnership, a limited partner is considered a stranger or a third kind. He is merely a contributor who has no right to take active part in its management. He can transact business with or extend loan to partnership, and he is considered a partnership creditor insofar as his claims are concerned. But as regards to his claims, he cannot receive or hold a collateral security and partnership property, or receive from a general partner or partnership any payment, conveyance, or release from liability, if at the time the assets of the partnership are not sufficient to discharge partnership liabilities to third persons. The violation of this rule is considered fraud of partnership creditors. To have priority over other limited partner as to the income and return of contribution is so agreed and stated in a certificate. In the absence of any agreement stated in the certificate, all the limited partners shall stand upon equal footing. Liabilities of a limited partner to the partnership. A limited partner is liable to the partnership as debtor for the difference between his contributions as actually made and that stated in certificate as having been made. For any unpaid contributions which he agreed in certificate to make the future at the time on the conditions stated therein. As trustee of the specific property stated in a certificate as contributed by him, by which was not contributed or which has been wrongfully returned, of a trustee of money or other properties wrongfully paid or conveyed to him on account of his contribution. Dissolution. A limited partnership is dissolved by the retirement, death, insolvency, insanity, of civil interdiction of a general partner unless the business is continued by general partners under the right to continue stated in the certificate or with the consent of all the partners. The retirement, death, insolvency, insanity, or civil interdiction of a limited partner does not dissolve a limited partnership as long as there is still at least one limited partner remaining. The only requirement in the case of retirement, death, insolvency, insanity, or civil interdiction of limited partner is to amend the certificate. Settlement of limited partner's liability after dissolution. In settling account after dissolution, the liabilities of limited partners shall be settled or paid in the following order: those outside creditors, those limited partners' share in profits, those to limited partners' capital, those general partners' advances, those general partners' share in profits, and those general partners' capital. QR Company Limited is composed of 5 general partners A, B, C, D, and E, and 4 limited partners W, X, Y, Z. They contributed 100,000 each to the common fund, and they agreed to divide the profit equally on dissolution. Its total assets amount to 2,188,000, and its liabilities are follows: 756,000 payable to creditors, 218,000 loan of payable to limited partners, 44,000 advances made by C and D. The partnership assets shall be distributed as follows: 794 amount payable to M and O and X, 200,000 profits to W, X, and Y and Z limited partners, 400,000 capital of W, X, Y, Z, 44,000 advances of C and D general partners, 250,000 profits of A, B, C, and D general partners, 500,000 capital of A, B, C, and D. Other important provisions regarding limited partnership. A person who has contributed to the capital of a business in erroneous belief that he is a limited partner does not become a general partner nor bound by the obligation of a partnership, provided that on ascertaining the mistake, he promptly renounces his interest in profits of the business or other compensation by way of income. And a person may be a general and limited partner in the same partnership at the same time, provided that this fact shall be stated in a certificate. As such, he has all the rights and powers, and he is subject to all restriction of a general partner. He is only considered a limited partner in respect to his contribution. Hence, his separate property shall be liable for partnership liabilities, and if he will be compelled to give additional contributions after partnership assets have been exhausted, he is entitled to reimbursement from the other general partners.